All right. I just want to say I think it's pretty pathetic that this library is arguing old law that then they want to blame me for having to cost them money in lawyer fees to make their bogus arguments about prescription, and there's a 1 year limit on that. They're making what they think are some great arguments about why there's a 1 year time limit, and even the Third Circuit Court of Appeals has put out this opinion that's like not official. It's not like published, but it's an opinion that we stand behind the strict 1 year limit, which this is a prescription, all right, that Louisiana calls a prescription, but I've researched it on ChatGPT. Other states call it the statutory limits. So they just want to change the words, but it's still the same thing, that there's a statutory time limit, statutes, something like that, something with statutes, and they want to call it prescription. Why don't they just call Louisiana prescriptions instead of Louisiana statutes? They're just going back and forth, just like they want to play around with parish instead of county, although they still got district, county judges and all that. They just want to play with certain words, maybe to try to think that people think that they're smarter or something. They want to change the language. They want to pull the Mormon. They want to be like Mormons and change the language of too much, making their own language to try to confuse most people. But I mean, ChatGPT sees through it because it can interpret different languages anyways on the fly. So for you to just try to make different words that are not common isn't going to fool the AI, isn't going to fool me as in the end result. So a prescription is the statutory limits, and they're arguing that it's a year. And apparently ChatGPT is telling me that national standard is 2 years, and just this last July 2024, the Congress in Louisiana changed from 1 year to 2 years. Now I'm outside of the limit, but that shows that they're going through a little bit of a change with that limit. And all the arguments that the library has made are under the 1 year limits. All the cases, the Third Circuit Court of Appeals, strict, sticking to the rules of, and there's no bending of the rules of this prescription and peremptory and all of that. And then suddenly, that was in 2022, and then suddenly in July 2024, the legislator turns around and says, "Oh, we'll give an extra year. We'll give it 2 years." And guess who has the hierarchy, the priority in the hierarchy? It's the legislature, not the appeals court, not the district judge, definitely not the city judge. The city judge makes no they have no, they're on the bottom of the level. They're on the lowest level of the totem pole, the city judge, and then you got district, and then appeals, and well, the legislator reflects the will of the people. Okay, so that's the overwhelming choice. Unless the appeals court wants to try to argue that it's unconstitutional what the legislator decided. And because there's murky grounds, and that had me questioning ChatGPT. Why did they change it to 2 years? What was the reasoning behind that? And it said that gives the parties more time to do their discovery requests, to figure things out before the lawsuit. Have more time to do investigations, because if you only give it a year, that brings more emotion into the argument, and less research. There's less research going on when there's a shorter time frame to respond, to make the lawsuit. And then it goes in, and then if you shorten up the time to investigate this, to look into it, to think about it, to talk it over, then it becomes more emotional, and it's more of a recent thing, like for the targeting insurance companies. So insurance companies, it's an emotional issue. When the day the injury happens, and in my case, it's for what the library said about me. All right, that's the let's see, emotional distress. I forget the exact word. Reputational damage. Defamation. For injury. Defamation is an injury, and it was 1 year, and now it's 2 years, and they're sticking with 1 year. And I think I can understand, if I look at it from their end, that the legislator did say something about everything before July is still 1 year. And I mean, still, it's what they've written as part of the law. It's what the judges are going to go off of. But still, the spirit of it being extended is something to argue and make the judges aware of. Okay. And that's what's going on. What if it could be pushed to 3 years? What if they find, maybe, why stop at 2 years? All right. They found, and Louisiana took one of the most extreme approaches with the 1 year time limit, and the national standard is 2. There could be some states with 3 years. Who knows? And there are exceptions. And in my case, this doesn't even apply. I'm an exception. This wasn't some like one-time deal for me. It wasn't one accident for an insurance company to annotate that this happened on this day, and then it's 1 year from that. My situation is an ongoing case. There, every day I wake up, every time that library opens, I'm banned from it, and it renews and resets. So, and I should give that background. So the argument is, the lifetime ban imposed by the library constitutes an ongoing injury, as I continuously am denied access to the library. When they open at 9 a.m. today, once again, I'm denied, and once again, it renews. Okay, under the continuing tort doctrine, prescription renews each day, the harm persists. And the library's arguing that it was a one-time thing. They just kicked me out one day, forever, and that's the end of it, without even having the open meetings law, without even following the open meeting law. And that's something that I actually want to add to this. I added to posts this response, but actually that's a separate argument, because the library sent out like 3 responses to my one lawsuit. So I'm going to make 3 responses. I'll keep them separate. And the first, what seems to be most important to the judge, and the judge is right on top of this 1 year prescription period. I have to prove now why they shouldn't dismiss the case because of this 1 year prescription. And it's pretty obvious. ChatGPT sees through it. Can a judge see through this? Obviously not. Judge Dias, she hasn't seen through this. Clearly, by suddenly, it seems like pinning the blame on me, that I have to show up, and it's not as important for the library. They make their arguments, and I mean, maybe it's because I just didn't make the argument in my lawsuit that about preemptory and prescription. I'll have to say, I think ChatGPT overlooked it a little bit, but maybe for good reason. Maybe it just didn't see it as applicable. And once again, they make the non-applicable arguments, which they're trying to make applicable, and it seems to have swayed the judge. And now I'm making my response that it's not. I don't have a 1 year prescription or 1 year statute of limitations. It's an ongoing lifetime ban. So it's really amazing that the library is even trying this. Don't they have the most recent books there on law? I mean, the library is supposed to be the source for the most updated information. They have a newspaper section, a magazine section, which I used to hang out in while I was defending myself in 2022 from the criminal charge, which is still ongoing. That's another thing I'm fighting. But a library hoping the library was hoping I didn't see that there was the peremptory prescription period changed from 1 year to 2 year in July 2024. I think they were hoping I wouldn't see that. And I probably wouldn't if I didn't have AI here. I mean, without ChatGPT, I'm sure Google Gemini would have seen it. I mean, I just plug in my arguments and I'm sure that would have come up at some point. And I confirmed. I was like, okay, really, is ChatGPT hallucinating? Nope. All I have to do is look at the sources, and there's 10 of them. Just click on the source, and they all repeat that the prescription, which has been in place since 1875, has changed from 1 year to 2 year. They held it. That Louisiana might be the last state to actually change from 1 year to 2 year. If other states even had 1 year, I don't know. But it had this law for over 100 years, and then just this last July changed it. So that's something, and that's not something to be ignored. All right, that's not something that just goes over people's heads. But I mean, they probably think it was going over my head. Oh, homeless guy trying to get his permanent ban lifted. Let's use this stupid argument. And the judge was right on top of it, all eating it up. Are they not aware? I'm sure they're got to be aware. But I'm making my response. I want to give it more time because I want to still think this through. I mean, I'm focused on what they're arguing about the 1 year prescription and how it applies to me. And let's see, the background. I got background. Let's see, I was arrested in the library January 22nd, 2022. Lifetime ban has resulted in ongoing harm, including reputational damage, emotional distress, and continual denial. Let's see, I filed my lawsuit on November 14th. IIED, intentional infliction of emotional distress. They have it acronymed IIED. Actually, I kind of want to look into that closer. So I got more things to look at. I have till January 17th for the next hearing to make my arguments why my lawsuit should stay in place. Let's see. Yeah, the Louisiana legislature amended Louisiana Civil Code Article 3493.1, extending prescriptive period for delictual actions. So I'm kind of making that argument, but then I'm also saying that it don't apply because it's an ongoing issue. So the defendant moves to dismiss my claims relying on the prior 1 year prescriptive period and asserting that my claims are prescribed. They assert my claims are prescribed. So I put this in posts. They extended it. There's an ongoing nature. And then I need to look at this relevant case, South Central Bell Telephone versus Texaco from 1982. I think I might ask ChatGPT to look for more cases about ongoing nature of harm extends the prescriptive period. So I'm not exactly saying, there's always a prescriptive period with harm. But as a lifetime ban, it's continually renewing every time the library opens and closes every day. Maybe not on Sundays so much, since that's when they're closed. But whenever they're open, I mean, if there's any meetings at the library, I'm prevented from attending them, and that's just not right, based on faulty information. Appeals. Let's see. The weakness of the 1-year standard, the shift to a 2-year period reflects the legislator's recognition that the prior 1-year period was insufficient. And I'm sure they had a lot of pressure from other states, maybe laughing at them. So I made the arguments why that it needed to be extended, and you can look that up very easily. Just ask a simple question to the AI, whichever you choose. All right, so yeah, I have my response, but I just want to think it over a little bit more, see if there's more I could add. But yeah, it's ridiculous because I make this morning. I make my response this morning. It takes like it takes just a few seconds for it to spit it out. I just got to input all the information, and they're probably going to want to charge me $1,000 for their responses when it only takes $20 a month and a few minutes for mine.